Good morning. My name is Kelly McGinn. I'm here from Northern Virginia today to stand with my sisters to oppose this terrible, old, dead-on-arrival amendment, the ERA. I'm a wife, I'm a mother, I'm a graduate of the University of Virginia Law School, and I'm here representing thousands of women in Virginia, millions across the country that recognize that this is a terrible, terrible idea for women. It's particularly ironic that in this 400th session of the Western Hemisphere's first representative assembly, that our General Assembly is taking up a bill that would transfer its authority over some of the most personal rights of Virginians, including marriage, divorce, family property law, adoptions, abortions, school, and sports from our state to the federal government. Section 2 of the ERA states that the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. Congress and the federal courts will thus decide, not the people of Virginia or any other state, what sexual discrimination is, and this will mean an avalanche of lawsuits, disrupting the lives of women in our state and across the country, who will no longer be able to rely on existing common sense laws to protect them when they're pregnant, if they suffer sexual abuse, when they're incarcerated, and even when they compete in sporting events. Now, the ERA may sound benign and symbolically important, but it failed in 1979 and ultimately in 1982 because people recognized its vague promises would not advance the cause of freedom and protections for women. This is even more true today, because Section 1 of the ERA does not even mention the word woman or women, referring only to equality of rights on account of sex, a term which enjoyed a common understanding in 1972, a man or a woman, but does not in 2019. And this would be going in our Constitution, a vague, undefined term. The whole point of a Constitution is it's a blueprint, right? It's a consensus of the governed. We cannot allow this to go forward. So it's inevitable that any person seeking to protect their rights, man or woman, under this amendment will need to seek the intervention of the courts and will not be able to rely on any laws that currently protect their existence as a man or a woman. It truly is a full employment act for lawyers. They will thank our assembly if this moves forward. Now, laws drafted specifically with women in mind that we all take for granted on issues like abortion, women's health, single-sex shelters for battered women, women's sports, accommodations for pregnant women, military service, and single-sex housing in prisons will likely be in jeopardy. The ERA is unnecessary in 2019. It's not 1972. Women are already well protected under the Constitution, and you've heard from my sisters. The 14th Amendment very clearly protects us. In fact, if you remember, in 1996, VMI was integrated by U.S. versus Virginia in a case that very clearly maintained that women had every right that men had to access education. There are also a long list of other laws: the Equal Pay Act of '63, the Title VII of the Civil Rights Act, Title IX, and others will list them off if they haven't already. Carefully crafted Virginia laws and regulations have also developed over the years to meet the specific needs of women, and all of these laws, federal and state, would be superseded by the ERA were it to become part of our Constitution, leaving women with less certainty of their actual rights under the law. The ERA, as currently written, is too extreme. It's bad for women, and women deserve better. Thanks for standing with me to oppose this.